This is ACSblog, and we're with Allison Zieve, the director of Public Citizen Litigation Group and a participant in ACS's Supreme Court review. On the panel today, you mentioned that you thought a trend developing from the Supreme Court is maybe not hostility, but a little bit of resistance to litigation, to lawsuits, to some smaller plaintiffs. Could you elaborate on that?
It seems to me that the court is consistently unsympathetic to class action suits, to broader suits, and has a distinct sort of anti-litigation trend in a lot of its cases. The court doesn't seem to feel that state law claims, tort claims, consumer protection claims have a lot of value, and so not only do plaintiffs frequently lose in those cases, but they do so through opinions that don't really show much respect for the civil justice system. And so I think that raises significant concern about people's ongoing access to the courts, access to court remedies. There's a lot of situations in which state law provides the only remedy, and the Supreme Court has been cutting those access to the court system off through a very sympathetic view of arbitration, a broad reading of the Federal Arbitration Act, through preemption, standing requirements that have been made more and more stringent over the years. So there's a lot of ways in which the courthouse doors are being closed to just regular people.
Was there, and I'll let you go in a second, but a case from this term that you could point to for us that as an example?
I think one of the cases this term that causes me most angst is AT&T Mobility versus Concepcion, where the lower courts that had reached it, the issue had sort of unanimity among the lower courts, state courts and federal courts of appeals, that in some situations a class action ban in a consumer contract or an employment contract that provided for arbitration could be unconscionable, because if you don't allow plaintiffs to band together when they have small value claims, in AT&T I think it was about a $30 claim, then they really have no remedy at all. It's not worth anyone's time to sue for $30, and certainly no one's going to find a lawyer. But there's a big value to society, I think, in allowing people to join together so that the corporation that has wrongfully gotten $30 from thousands of people is deterred from doing that in the future and has some accountability. And although the lower courts had all seen this in about the same way, they'd struck down the class action bans in cases where it meant that really the corporations wouldn't be held accountable, and they acted as exculpatory clauses, and they'd allowed the class action bans in situations where they thought an individual really could go through, would have the ability to sue on their own. The Supreme Court struck down the state contract laws that said that those class action bans can be unconscionable in certain circumstances, and just said no, that the policy behind the Federal Arbitration Act of encouraging arbitration would override state law, even in a situation where the consumers or the employees might not have a remedy.